So very good evening everyone, welcome to Bajirao IAS Academy 2025 mains question answer analysis. And in fact, so till yesterday we have discussed Gender Studies paper 1. From now onwards we'll be discussing Gender Studies paper 2. And in fact, through this analysis we'll be understanding the important themes in different papers. And because if you understand the important themes, UPSC has been regularly repeating those themes itself. And if you get to know what are those important themes, so it will make your preparation easier. And apart from that, we will also understand how to structure the answer and how to improve our presentation skills, everything, so that it can actually provide us important insights about answer writing. So the question that was asked in the paper was, discuss the corrupt practices for the purpose of Representation of People Act of 1951. And in fact, Representation of People Act 1951 is itself given in the syllabus of Gender Studies paper 2. So therefore it has been directly asked from the syllabus of GS2. Now analyze whether the increase in the assets of the legislators and their associates disproportionate to their known sources of income would constitute undue influence and consequently a corrupt practice. Now if you look at the question, it may seem that it is a lengthier question. Yes, of course it is true that it is a bit lengthier question. However, so we all knew that in politics, the corruption or criminalization of politics is a common phenomenon in Indian politics. And in recent times, the corrupt practices have also been increasing, and the corrupt practices also leads to the money and muscle power, or they even reinforce the corrupt practices in the politics as well. So therefore, first they have asked that discuss corrupt practices for the purpose of Representation of People Act 1951. And in fact, there are certain corrupt practices, for example, money power, muscle power, bribing officials, so all these things comes under the corrupt practices followed by the politicians to win the elections or increase the chances of winning elections. Now in this context, analyze whether the increase in the assets of the legislature and their associates, for example, in this case, imagine a legislator and his or her assets have been increased disproportionately compared to the known sources of income, and would constitute undue influence or consequently a corrupt practice. For example, imagine that a particular individual who is earning income from the agriculture as a source, right? So despite agriculture as a source, his income is much more higher than the his profession. So therefore the question has been asking us that this unknown sources of income will have an undue influence in the election of that particular candidate. So whether it amounts to the corrupt practices or not, right? So if you look at the model framework of this answer, in the introduction you just have to mention about section 123 of the Representation of People Act 1951, right? So because it has defined the corrupt practices in this particular legislation. And apart from that, you should also emphasize on the need for safeguarding the electoral fairness as well, because free and fair elections is an important principle of the Election Commission of India, or for a democracy it is an important principle, right? So in the body part of the answer, you have to mention the list of corrupt practices. For example, bribery is a corrupt practice, undue influence on the voters is a corrupt practice, and appeals to religion, caste, false statements of misuse of official machinery, so everything comes under as part of the corrupt practices. Secondly, analyze the disproportionate asset increase, right? So irrespective of a particular provision, irrespective of profession of an individual, so the individual, he's earning disproportionate assets, or he's having disproportionate asset increase alone is not undue influence, right? So only when used to manipulate the voters does it become a corrupt practice. Now here the question may seem complex, but first of all you have to understand the key theme of the question, right? So the question has been clearly asking us that the 1951 Representation of People Act says that there are certain practices which are called as the corrupt practices. There are certain practices, those are practices are known as corrupt practices. For example, bribery is a corrupt practice, right? So muscle power and money power is also a corrupt practice. Now in this case, every contestant in the elections, so they may have a certain income source, So they may have a certain income source. Now imagine that this particular contestant, so this particular contestant have a disproportionate asset. So this disproportionate assets really influence the voters. So influence the voters in an unfair means. So that this candidate may increase his chances of winning elections. So this is what it has been asked. So if you say that this disproportionate asset increases the chance of winning elections of this particular candidate, so you have to prove this correct with examples and data. So if you say that not all cases this disproportionate assets will actually influence the voting process, then also you have to provide examples and data to support your arguments. So I hope it is clear for you, and ultimately you have to conclude the answer mentioning or emphasizing on the need for free and fair elections. Right? So free and fair elections is essential and necessary in a democratic country like India. Right? So in the introduction of this answer, what you have to write? So before writing an introduction for this answer, first of all you have to understand that we have the Representation of People Act of 1951. It is a legislative framework. Right? So this legislative framework provides for the free and fair elections. Right? So it provides for the fair elections in India because it has identified certain practices as the corrupt practices. Right? So therefore the Representation of People Act will identify and also prohibit these corrupt practices, and it also upholds the integrity of the overall democratic process. Right? So for this particular purpose, the Representation of People Act 1951 was passed. Now you can see here the Representation of People Act. So conducting elections in a free and fair manner, disqualification and qualification of the candidates, and the corrupt practices, because it has identified certain corrupt practices and it also prohibits those corrupt practices and it also defines those corrupt practices. And then the election disputes, administrative machinery, and registration of the political parties. So everything will be dealt by the Representation of People Act 1951. So I hope it is clear for you, right? So when I say Representation of People Act 1951, it is a legislative framework that has been passed by the Parliament. So therefore, this legislative framework provides means for the fair elections in India, and it has also identifies and also prohibit the corrupt practices and uphold the integrity of the election process or democratic process in India, and that is the essence of the Representation of People Act. Now in the introduction of the answer, you can just mention that there are certain corrupt practices. For example, bribery is a corrupt practice. Using money power and muscle power is a corrupt practice. Now in fact, the corrupt practices are defined under the Representation of People Act. So as per the definition of the Representation of People Act, the corrupt practices are those practices which vitiate the fairness of the elections. Now in fact, in India, elections need to be conducted in a free and fair manner, but any corrupt practice that will vitiate the fairness of the election process, and it will further undermine the public trust. Right? So it will undermine the public trust, and it violates the prescribed standards which are laid down for conducting free and fair elections in a country like India. Right? So therefore, this is how the corrupt practice has been defined by the Representation of People Act. Now remember, whenever corrupt practices have been asked in the Representation of People Act, or asked the corrupt practices and the Representation of People Act has been asked in the UPSC Mains examination, you must define the corrupt practices as given in the Representation of People Act of 1951. So that makes your introduction more and more appealing. Now, corrupt practices under the Representation of People Act of 1951. So let's look at the corrupt practices. So what are these corrupt practices? Now in fact, there's a separate section which is section 123 of the Representation of People Act. So this Section 123 of the Representation of People Act considers that there are certain offenses or certain practices which are considered as the corrupt practices. So let's understand what are the different corrupt practices which are recognized and identified by the Representation of People Act 1951. Now, the firstly, bribery. Now, what exactly is a bribery? Bribery means accepting or offering monetary gratification to influence the voting decisions. For example, you belong to a particular constituency and the contestant has been giving you the money so that he can get the vote of the people who are living in that particular constituency. So that essentially means, so monetary gratification to influence the voting decisions is what is called as bribery, right? So in India, bribery is one of the most pressing challenge, right? So in fact, in 2019 general elections, so authorities have seized over 3,456 crore rupees. So therefore, there is a huge influence of money power in the elections, and this bribery is also one of the major issue that the Indian election process has been facing, right? So in fact, it has also been affecting the free and fair conduct of elections as well, because you can easily influence the voters by giving them the money, right? So money power and the muzzle power, right, or giving bribery or bribery is also another major challenge. And apart from that, we need to talk about the undue influence, right? So undue influence is also another major challenge that we have been facing when it comes to conducting free and fair elections. Now, when I say undue interference or undue influence in the election process, so it has been defined as direct or indirect interference with the free exercise of any electoral right. Now, if you are a citizen of India and if you are above 18 years of age, so irrespective of any distinction like place, religion, region, caste, gender, so irrespective of any such distinction, you will be given your voting right, right? So therefore, this undue influence is defined as direct or indirect interference with the free exercise of any electoral right. So any individual should not have any limitations, any restriction, any undue influence when it comes to exercising his right to vote, right? So such as, for example, threatening the voters, right? So if they don't give vote to a particular individual, so they may cause harm, right? So threats also amounts to undue influence. Injury also amounts to the undue influence, and social ostracism, social boycott, and spiritual coercion, right? So everything is part of the undue influence of the voters. For example, threatening voters with the community expulsion or community boycott or social boycott or religious censure to sway their votes, right? So these are under the undue influence of the voters. They influence the voters to exercise their free will when it comes to exercising their right to vote. And this also amounts to a corrupt practice under the Representation of People Act section 123. Secondly, false information or spreading hate speech. So this also amounts to the corrupt practice. Now, in today's elections, what exactly happening is that the candidates who are contesting elections, they are very often using the hate speech or spreading the false information so that they can mobilize the voters, right? So spreading misinformation about the religion, about the caste, right? So these are all the major issues that the Indian democracy has been facing when it comes to conducting elections in a free and fair manner. So therefore, spreading false statements about the candidates, the character, and also promoting enmity among citizens based on religion, caste, and language. So these are some issues that the Indian democracy as a whole has been facing. There are several examples where the leaders have been using hate speech against a particular religion or a particular caste or particular community so that they can mobilize the majority votes. And other corrupt practices including the use of government resources, right? For example, whenever any government which is in power, and if they again go for the elections, right? So they again contest elections, so they may use the government resources for their advantage, for their benefit during campaigning, and in fact exceeding the spending limits given to them, and booth capturing, right? For example, in some regions, so the people who are having the muscle power, they can actually capture the polling booth, so this is known as polling booth capturing. And even personation also falls under this scope of corrupt practices, right? So these are some corrupt practices which were defined under section 123 of the Representation of the People Act. Now let's understand, we get to know that there are some corrupt practices which are defined under the Representation of People Act 1951, right? So do you think that this disproportionate asset increase, does it amount to undue influence of the voters to exercise their right to vote? So let's understand this concept as well, because it has been asked in the question specifically. Now if we talk about the legal context, so legislators must disclose their assets as per section 33 of the Representation of People Act, and Supreme Court orders in Association for Democratic Reforms versus Union of India case 2002, right? So whoever contesting elections, so they must disclose their assets as per the Supreme Court orders and also section 33. However, just a disproportionate asset growth for a particular candidate, it does not automatically translates to the corrupt practice. So there are some exceptions also. For example, there has been a disproportionate increase in the assets of a candidate, that doesn't mean that it will ultimately lead to the corrupt practice under the Representation of People Act. So unless he's going for the bribery or undue influence of the voters, or he is using the hate speech, right? So it doesn't mean that he will do it amounts to the corrupt practice, right? So it will be typically prosecuted under another legislation, which is the Prevention of Corruption Act of 1988. Now then we'll have to understand the judicial aspect as well. So if we talk about the judicial aspect of it, now Supreme Court in Lily Thomas versus Union of India case in the year 2013 and Krishnamurthy case 2015. So the Supreme Court has clearly ascertained that unless there is a clear evidence, so the disproportionate increase in the assets have been used to manipulate the voters. Yes, so understand that there is a candidate and there is a disproportionate increase in the assets of this particular candidate, and Supreme Court in Lily Thomas case and the Krishnamurthy cases. So unless the disproportionate increase in the assets were used to influence the voters in an undue manner or manipulate the voters, for example vote buying, intimidation, bribery, an increase alone does not constitute the undue influence or corrupt practice, and this is what the Supreme Court has clearly mentioned. Remember, whenever you are writing an answer, it is very, very important that you must quote these cases. The Lily Thomas case, the Krishnamurthy case in the year 2015, and Association for Democratic Reforms versus Union of India case 2002. Now, one best example is, imagine that if a candidate uses unexplained wealth to distribute gifts to the voters, right? So unexplained wealth is being used to distribute gift boxes to the voters. It could be considered, or it amounts to the bribery, and it influences or manipulates the voting choices of the people. And conversely, unexplained asset growth. So in case there is an unexplained asset growth for this particular individual without proof of electoral use, then it does not breach section 123 of the Representation of People Act, because section 123 of the Representation of People Act deals with the corrupt practices. So mere increase in the assets of a particular individual does not mean that it amounts to the corrupt practice. So I hope it is clear for you. Now if you look at the data, several reports have been highlighting that between 2014 and 2019, so there were around 1000 MLAs and MPs, right? So around 1000 MLAs and MPs saw their assets increase by around 100% or more, right? So but only a handful faced the disqualification under section 123 of the Representation of People Act, because not all the MPs or MLAs who have seen disproportionate increase in the assets, so they have done the corrupt practices under the Representation of People Act. So mere increase in the assets or the asset growth of MLAs MPs does not mean that they have practiced the corrupt means, right? So they have won the elections through the corrupt means. I hope it is clear for you. And in the conclusion of the answer, what you have to write, right? So you have to emphasize on the need for conducting elections in a free and fair manner, and you should stress on the need to check criminalization of politics. You need to check the need to prevent the criminalization of politics, right? So already we have a Representation of People Act of 1951, and this Representation of People Act 1951 so clearly defines what constitutes a corrupt practice. It also defines what constitutes a corrupt practice. However, just a mere increase in the assets of a legislator, it does not mean that he follows the corrupt practices, right? So there will be an undue influence on the voters. We cannot come to that conclusion unless the increased assets are being used for certain or to manipulate the voters in his favor, right? So therefore, in this context, there is a need for comprehensive reforms and stricter disclosure norms. So they are being needed to bridge this legal gap and also to reinforce the legal integrity in India. So that's how you have to write the conclusion in this answer. So I hope it is clear for you, and even if you have any doubts on this, you can ask those doubts to us. Now the next question. So this question is on the administrative tribunals. So comment on the need of administrative tribunals as compared to the court system, right? So why we need to have the administrative tribunals as compared to the court system? So how administrative tribunals are different or special compared to the court system? And in the second part of the answer, you need to assess the impact of the recent tribunal reforms through the rationalization of tribunals made in the year 2021. And in fact, this question is about the tribunals. And in UPSC syllabus, you can, if you go through the UPSC syllabus, so judicial and quasi-judicial bodies, so it has been mentioned in the UPSC syllabus. So therefore, you just have to go through the administrative tribunals as well. So firstly, you have to briefly introduce the tribunal system in India, right? And how the tribunals in India are special. And secondly, you need to assess the impact of recent tribunal reforms through the rationalization of tribunals made in the year 2021, right? So in the intro of this particular question, what you have to write? So in the intro of this question, so you have to mention that the administrative tribunals actually offer speedy and specialized justice. So that's how the administrative tribunals are different from the existing traditional court system. And administrative tribunals also have the expertise or specialized or knowledge. Now in the body part of the answer, you just have to mention that how we need why we need administrative tribunals as compared to the court system, because the administrative tribunals are less formal, more flexible. So you have to mention all these things. And then you can also mention that there is a huge judicial backlog or pending of cases. Now around 4.5 crore cases are pending across the judiciary through various courts, right? So there is pending or backlog of cases, and because of this reason, there is a need to establish administrative tribunals so they can ensure a speedier justice, so faster disposal rate as well. And then you need to talk about the 2021 reforms among the tribunals, reforms within the tribunals, right? So reforms in the functioning of the tribunals. So you have to mention this aspect as well. Now in the conclusion of the answer, what you have to write? So in the conclusion of the answer, you need to mention about the essential role that tribunals perform, right? So you have to mention that administrative tribunals are important and they are essential, and at the same time they also there is a need to ensure efficiency of these tribunals, and there is a need to increase accessibility, and there should be more autonomy to uphold the justice as well. So you have to make sure that the conclusion is positive and optimistic in nature, so therefore it will be more impressive, right? So in the introduction of this question answer, what you have to write, right? So first of all, you need to talk about the constitutional provisions which specifically deals with the administrative tribunals. Administrative tribunals are quasi-judicial bodies. They were established under Article 323A and 323B of the Indian Constitution. If you write any answer in the UPSC Mains examination, particularly for General Studies Paper 2, it is always advised that if it is related to any constitutional provision, so please introduce the constitutional provision to make it more and more impactful. Here the administrative tribunals are specifically deals with Article 323A and Article 323B of the Indian Constitution. And if we talk about the administrative tribunals, so they ensure specialized functions or specialized dispute such as the service matters, taxation, company law and environment. So these are known as the specialized disputes. So therefore tribunals are specifically deal with the specialized disputes where tribunals have the expertise. On the other hand, the traditional or conventional courts don't have the expertise to deal with all these matters. And apart from that, the pending or backlog of cases in the conventional judiciary is also another major challenge that led to establishment of the tribunals for the speedier delivery of the justice. And if you look at the objective of establishing tribunals, they provide speedy, expert and cost-effective justice, and they also reduce burden on the regular courts as well, right? So I hope you have understood about this, and if you want to go through the other details, so you can also go through the details about the administrative tribunals, because the 42nd Constitutional Amendment Act, so that was passed in the year 1976, has inserted Article 323A and Article 323B, right? So it has provided for the administrative tribunal, and the objective of establishing these administrative tribunals is to provide a speedy justice, expert, cost-effective justice, and also reduce the burden on the regular courts because of the pending cases. Now let's understand what exactly is the need for establishing the administrative tribunals and the court system. Because we already have the court system, then why there is a need to establish the administrative tribunals? And that would be a major question which is repeatedly asked. Now in fact, the tribunals have the specialized expertise. So there are certain specialized disputes, and those specialized disputes would need to be resolved through the expertise, and tribunals provides the expertise, or they have the technical knowledge, right? So the technical knowledge will help solve the complex administrative matters. For example, the Central Administrative Tribunal that deals with the service disputes, and National Company Law Tribunal that deals with the corporate issues. This is the first advantage of creating the administrative tribunals, because they have a specialized knowledge, expertise to dealing with different matters. Secondly, the speed and efficiency. So because of the pending and backlog of cases in the conventional judiciary, the problem is that the cases are actually pending for several years. So when you have established the administrative tribunals, there is a chance that these cases might be heard in very less time, and justice will also be delivered in a speedier manner. So therefore, the administrative tribunal will ensure speed and efficiency, and they will also reduce the burden and the pendency of the conventional courts as well, since around 4.5 crore cases are pending across the judiciary at different levels. Now if we have established such a special quasi-judicial bodies, so they can actually reduce the burden on the conventional judiciary. Thirdly, the cost effectiveness, right? So it is cost effective and also affordable as well, because tribunals very often have a lower or less litigation costs, and there is a simplified documentation, and there are no mandatory legal representation to improve access to justice, right? So tribunals will further enhance access to the justice. So this is another major advantage of having the administrative tribunals. And then decongestion of courts as well. So remember, when you have established the fast track courts, special courts, administrative tribunals, and when you make sure that some of these pending cases are dealt by these administrative tribunals, so of course that will decongest the existing courts, because a huge number of cases are pending with the different courts. Now when you make sure you set up a quasi-judicial body and make sure you give certain cases to those quasi-judicial bodies, over a period of time you decongest the existing courts. So therefore the tribunals reduce the caseload pressure on the high courts and the Supreme Court, right? So thereby allowing courts to focus on the broader civil criminal cases and the constitutional matters. And what is the impact of 2021 tribunal reforms? So let's understand the impact of 2021 tribunal reforms as well, because this is the second part of the question and we should also go through the 2021 tribunal reforms as well. Now firstly, it has rationalized the functioning of the tribunals, because the several tribunals which are having the overlapping functions. Now these tribunals having overlapping functions are merged to streamline the administration, avoid duplication, and also improve their overall efficiency. So this is the first advantage of the tribunal reforms of 2021. Secondly, it has brought in several positive outcomes, and the several positive outcomes essentially means that there is a potential for better resource utilization and reduced fragmentation in adjudication. So third, there are certain concerns, and those concerns are also being addressed through the tribunal reforms of 2021. Right? For example, risks to independence and accessibility due to centralization, and even some fear increased delays or reduced local access as well. However, if you look at the Supreme Court's role in the tribunal reforms of 2021, the court has stressed on the need for transparency and independence in the functioning of the tribunals. It is good that you have established the tribunals, and the tribunals are also successful and they are efficient when it comes to delivering justice in a quick and speedier manner, but there is a need for more transparency and independence in the functioning of these tribunals. And in fact, the Supreme Court even questioned government material for reforms as well, right? So this is the impact of 2021 tribunal reforms. So it has brought in rationalization. It also brought in several positive outcomes as well. However, there are certain concerns, and in fact, Supreme Court has also expressed its opinion on the tribunal reforms of 2021. Ultimately, in the conclusion of this answer, what you have to write. So we all knew that the tribunals are efficient, so they deliver speedier justice, and they are also cost effective and affordable. So we have a lot of advantages. So despite such advantages, there are some challenges also, there are some concerns also when it comes to the functioning of these tribunals. So therefore, we should address those concerns associated with the tribunals. And when we make the tribunals function much more efficiently in a transparent and independent manner, there is a chance that the pending cases or the backlog of the cases or the excess burden on the conventional judiciary will be reduced. Right? So this is how you have to write the positive and optimistic conclusion in this answer. Right? So next we'll be talking about another very important question. So, every year UPSC asks question about comparison between Indian president or USA's president, comparison between India's parliament, USA's parliament, so comparison between the judiciary of India and some other Western countries. So there are some important countries, UK, France, US, Japan. So therefore, very often at least one or two questions they ask from this particular topic. So therefore, this is very, very important, right? So the question is, compare and contrast president's power to pardon in India and the USA. And are there any limits to it in both the countries, and what are the preemptive pardons? Right? So this question has 3 parts and you need to address the 3 parts. And in the introduction of this particular question, it was always advised that you start this answer with the constitutional provision that deals with the president's power to pardon in India. Or if you know, you can also mention the relevant provision with respect to USA as well, right? So this has these three different parts. Now in the introduction you write that Article 72 of the Indian Constitution, it deals with the pardoning power of the president. And similarly in US, under Article 2 Section 2 of the Constitution deals with the pardoning power of US president. Now in the body part of the answer, you have to mention the scope of the pardoning powers of the Indian president and US president, and then you need to talk about the discretionary powers that they have, whether they have any discretionary powers when it comes to pardoning. And then you should mention about the limits. So if they have any limits, and what is the preemptive pardon. So you have to address all these parts in the answer, only then it will become a holistic and a comprehensive answer, and there is a probability that you will get a good marks in such answers. Now in the introduction, so when you write the introduction for this particular question, what you have to write? Now remember, as I've already told you, when you write introduction for the polity question, it is always advised that if it is associated with any constitutional provision, you just mention the constitutional provision to make it more and more impactful. Now here, the president's power to pardon is a constitutional power. Now constitutional itself talked about the pardoning powers of the Indian president. So in certain cases, the Indian president can actually grant mercy and also rectify the judicial errors as well. In India, Article 72 of the Indian Constitution deals with the pardoning powers of the president, while in United States of America, it is provided by Article 2 and Section 2 of the US Constitution. However, both in India and US, they serve as a checks on the judiciary, but they differ in their scope, their discretion, and the limitations that they have. Now in fact, this question also says that the compare and contrast between the pardoning powers of Indian president and the president of United States of America, right? So in fact, the pardoning powers have been provided by the Constitution of India to check on the judiciary, or the excess powers of the judiciary, or miscarriage of justice by the judiciary. Now let's understand the body part of the answer, what you need to write in the body part of the answer. Now, what is the constitutional basis? Remember, as I've already told you, that Indian Constitution itself provided pardoning powers to the president under Article 72 of the Indian Constitution. So therefore, it has empowered the president to pardon offenses under the union law, court-martial cases, and even the death sentences as well. So these are the different punishments under which the president can actually pardon. And in USA, Article 2 Section 2 grants power to pardon the federal crimes, excluding state offenses and impeachment cases, right? So this is the constitutional basis of pardoning powers for the president of US and the president of India. Now let's understand the scope and jurisdiction of the pardoning powers of both Indian president and US's president. Now in fact, if we talk about the scope and jurisdiction of India's president, that the pardoning powers actually covers the union and military offenses, death penalties, even for the state crimes. In fact, governors have the pardoning powers limited to state offenses, excluding the death sentences. Because with respect to death sentences, only president have the pardoning power. Governors don't have the pardoning power. However, governors have a pardoning power, but those pardoning powers of the governor are just limited to the state offenses, right? So in fact, US president can only pardon the federal offenses, not the state offenses, because the state crimes fall under the state governors. So state governors will take decisions with respect to these issues. Now, if we talk about the discretion and the process of giving pardon or providing pardon to certain offenses and the punishments. Now, Indian president act as on the aid and advice of the Council of Ministers as per Article 74. Article 74 of the Indian Constitution So there is a council of ministers and the president provides pardon for certain offences based on the aid and advice of the council of ministers. So therefore it reflects the parliamentary oversight. However, US president exercise independent discretion without the obligatory executive advice. So there will be no obligatory executive exercise or advice to the US president. So he acts on his independent discretion. Now, if we talk about the judicial review, in India, Supreme Court can review pardons to guard against the arbitrariness and malified exercise of the pardoning powers of the governors and the president. And in fact, so one such example is Ipuru Sudhakar case. So in this particular case, the Supreme Court has acted against the arbitrariness and malified exercise of this pardoning powers of the president and the governor. However, when it comes to US president, so US presidential pardons are largely immune from the judicial review, right? So they are immune from the judicial review. So if we talk about the limits, so there are certain limits. So let's understand the limits for the pardoning powers of the President of India and President of United States. In India, no power to pardon impeachment cases and preemptive pardons are not recognized, right? So in fact, the pardoning powers of the president generally follow a conviction. However, USA, they cannot pardon impeachment cases and uniquely permit a preemptive pardons. So for example, before trial or conviction, right? Now, in fact, if we talk about the preemptive pardons, so they are actually exclusive to the United States of America. That essentially means that allowing pardons before the charges or the convictions. Now, in fact, example is President Ford's pardon of Nixon. However, India does not allow any such pardon before the judicial determination. So preemptive pardons are those pardons which essentially means that giving pardon to an individual even before court determining the charges or court imposing any conviction or punishment on an individual. So that is what is called as preemptive pardons. And if you look at the recent data and examples, US saw nearly 1500 pardons granted in 2024-25. So therefore it has been reflecting the active presidential use of the pardoning powers. Active presidential use of the pardoning powers. But on the other hand, India's pardons remain rare because they were rarely used. Notable is 2022, where pardon in Rajiv Gandhi assassination case has been provided. Right, so this was one example of giving pardon to the convicts. Now, in the conclusion of the answer, what you have to write? So, in fact, India and US, the presidents enjoy the pardoning powers, right? But they treat pardoning as a humanitarian executive check on the judicial authority, right? So in fact, India's pardoning system emphasizes on the institutional accountability through a ministerial advice and judicial oversight. But on the other hand, in US, it is the presidential discretion to give pardon. So in fact, the US model grants president greater independent discretion when it comes to giving pardon, including the ability to grant preemptive pardons, highlighting the fundamental constitutional distinction which is rooted in their respective governance structures, right? So this is how the pardoning powers of Indian president and US president differs significantly. And that's all in this lecture, and thank you so much. And if you like our analysis, please subscribe our YouTube channel and also hit the like button. Thank you.